Hello, Alison Colley here from Real Employment or Advice. This is a short presentation that we have delivered today, the Friday the 24th of July, for our HR Harbour members, exclusively for them on a live webinar. And this is just a recording of the slides and content for your information. What I'm going to be covering in this 30-minute or so presentation is a little update there on the furlough scheme, some details about the notice periods and furlough, the furlough grant and settlement agreements as a tool to resolve disputes. The first thing I want to talk about is the furlough scheme. By now, many people will have heard of the furlough scheme and will have an understanding about it, and many more people will have been furloughed. As you can see there, the latest statistics say that around 9 million employees have been furloughed across the UK at some point or another. And I know that from talking to a number of our customers that there are a number of people who are utilising the flexible furlough scheme and so are flexibly furloughing their staff, starting from the 1st of July and running through until the end of October when the scheme ends. A little recap on some key points to note here. As I was saying, the flexible furlough scheme was made available from the 1st of July, which means that employers can flexibly furlough their employees, and there's no limitations on this. As long as the employee has previously been furloughed, they can be flexibly furloughed, which means they can come back to work for any amount of time. And the remaining time that they're not working can be recovered under the grant scheme. There are increased costs for the scheme from the 1st of August 2020. So for those employers who are paying the 80% staff who are furloughed, from the 1st of August, it will no longer be sort of a cost neutral. It will be a contribution to the pension and national insurance will be required. And then from the 1st of September, it's the pension, NI and 10% of the top up to 80%, and then from the 1st of October that increases to 20%. So employers, certainly who I'm speaking to, are starting to plan ahead for those increased costs and budgeting. At the moment, the scheme is due to end on the 31st of October. There hasn't been any announcement about any extension. There is lots of speculation and talk about whether the scheme will be extended. I know some people are calling for it to be extended in certain industries, and depending on what happens, I think in the next couple of months in relation to the virus and local lockdowns and that sort of thing, we may see some form of an extension to the scheme if the virus does continue and there are restrictions continuing in place throughout October and beyond. One thing that I would like to note here is, according to media reports, HMRC have begun investigations in relation to fraudulent furlough claims and claims under the scheme. Now, whether that's true or not, I don't know, but certainly there have been some high-profile cases where people have been completely fraudulently seeking to utilise the scheme and have been dealt with accordingly. But certainly I would think that there are going to be random checks made in relation to claims, and employers will be audited who have claimed under the scheme to check that it's been done correctly and that they aren't fraudulent. The most important thing for employers, therefore, is their record keeping. It's really important that you keep a good record of what you're claiming, what hours employees are working, and where possible, you should correspond with employees to ensure that they also have a record of what's happening. Now, I know that there are many businesses where it's very difficult to predict what hours an employee may be required to work under the flexible furlough scheme, and you may just want to keep it fairly fluid. But if there are substantial changes, they should be notified to the employee in writing. And definitely if you have a situation where somebody is asked to come back, let's say 2 days a week, but you decide actually we're busier than I expected and we need them 3 or 4, then you should then issue another letter to the employee clarifying the change to what's required in terms of flexible furlough. The records you have, the correspondence with your employees, is going to form your basis of your evidence should you be audited, and to be able to show that actually you have been claiming legitimately under the scheme. Now, I have read some cynical reports online where people are suggesting that the government will be wanting to recoup some of the money that they have paid out for the furlough scheme, and will therefore be going hard after employers to recover any money that's being claimed wrongly. I don't know whether there's any truth in that or whether it's just a cynical approach. Certainly, given the potential economic future for the country in the next 6 months, I think it would be very difficult for HMRC and for the government to be seen to be penalising employers who were utilising the scheme fairly and reasonably to save their businesses. But who knows? From my perspective, my best advice to you is to make sure you have really good records available. The next thing I want to talk about is the notice period and furlough. Now, there has been some guidance recently which provides some much needed reassurance for employers. When the Treasury direction was released most recently, a number of people were concerned about the wording of the direction, and basically were concerned that it said that the furlough scheme was there for employers who were retaining employees. And there was lots of talk online about whether employers who were making redundancies or cutbacks or terminating employment in any way could still have the benefit of the furlough scheme. And this led to a lot of people panicking about whether they could actually recover some pay if they furloughed an employee who was taking their notice, who was serving their notice period. Helpfully, the guidance from HMRC was updated on, I think it was the 17th of July, just to make it very clear that here, as I've said here, where you make redundancies, you should do so in accordance with normal rules. This includes giving a notice period and consulting staff. You can continue to claim for a furloughed employee who is serving a statutory or contractual notice period. However, the grants can't be used to substitute redundancy payments. So this means that if you are making somebody redundant and you serve them with notice and you keep them furloughed during the notice period, that you can continue to make a claim under the scheme. Obviously, for employers who are making redundancies, there is a cost involved to that. So there would have been the notice pay plus the statutory redundancy pay, and maybe a payment in lieu of any holiday. So this is really helpful for those employers who have furloughed staff and need to make cutbacks. You can't claim, however, if you make a payment in lieu of notice. So that is where you give somebody a notice to terminate their employment with immediate effect and agree to pay them. So if somebody has a notice period of 1 month, for example, you tell them on the 31st of July that their employment is ending by reason of redundancy with immediate effect, and you're going to pay them. So their employment ends on the 31st of July, but they get a month's pay for their notice period. You can't claim that back. It's only if they are effectively remaining an employee, although albeit on furlough throughout the notice period. And then, as it says there, just to reiterate, you cannot reclaim redundancy pay. So if you are making redundancies or you're considering redundancies, you need to keep in mind the potential statutory redundancy costs that you have to pay out at the end of the consultation and notice period. Now, the Furlough Grant, I'm sure you would have heard about this in the news, is a grant that was announced as part of the government's way or means of retaining employment. I was hoping that the guidance would be out by today, but actually it says it's going to be out on the 31st of July, which will hopefully give more details about how it's going to work. What we do know, however, that it's going to be a £1,000 one-off payment for every previously furloughed employee. So every employee who has been furloughed you'll receive £1,000 for that employee. The employee must be continuously employed through till the end of January 2021. So it is a bonus for retaining them in employment with you. They must earn above the lower earnings limit, which is currently £520 per month on average. So this again prevents employers from keeping people on 0-hour contracts, or potentially keeping them on for, half a day a week or something like that. They have to have a minimum earnings, which equates, if it was £520 per month over the course of a year, to just over £6,000. The period of earnings for this purpose is between the end of the job retention scheme and the end of January. Now, I have assumed here that what they mean is the end of the scheme altogether, so from the 1st of November to the end of January. I'm not sure if that will be the case, or if they actually mean from the end of the employee being furloughed. I think it's probably the former rather than the latter, but I've just put there, I assume, and that will be clarified. Now, what this led me to think about was those seasonal businesses who are maybe shut down over the winter or who slow down over the winter. They may not be able to benefit from this one-off payment if they are not open or not able to provide employees with enough work over winter to meet the minimum earnings requirement. So particularly where we're based on the Isle of Wight, there are a number of seasonal businesses who either scale back considerably or who do actually close from December and January, and therefore they may not benefit from this £1,000. When this was first announced, I did put on LinkedIn a question to see what people's thoughts were on whether this £1,000 one-off payment would be enough to retain employment or have the effect or impact that was hoped. And overwhelmingly, most of the people I've spoken to have said that actually it makes no difference to decisions about redundancy. Of course, it would be a great bonus to have that injection of cash to the business in February next year, but actually it's not going to prevent me from making a redundancy now, because £1,000 versus the cost of retaining an employee between July and January is nowhere near what the costs would be. Of course, when the further information is available, we'll make this available to you and try to digest it and put it into straightforward terms that you'll understand as well, and answer any questions that will inevitably arise as a result of this. So that's the end of my update on the furlough scheme and the furlough grant. I'm just going to talk briefly about settlement agreements and using them as a tool to resolve disputes and make reductions within the workforce. Now, the reason why I've included this in today's presentation is because we are seeing a lot of employee clients coming to us who have been given a settlement agreement by their employer because the employer is going through redundancy or making reductions. So it's important that as a business you understand that this is a tool that you could potentially use to resolve issues. So what is a settlement agreement? Well, about 7 years ago now, settlement agreements, it was renamed settlement agreement. It had previously been called a compromise agreement. So you might have heard the term compromise agreement, and occasionally you might still hear the term compromise agreement, but essentially it's the same thing. It was renamed because it was thought that settlement agreement better reflected what it's used for. In short, it's an agreement between an employer and employee where, in return for compensation, the employee agrees to give up their employment rights, and most of the time they also agree to terminate their employment. An employee cannot legitimately give up their employment rights otherwise, save for in a settlement agreement, or they can do if they've had assistance from ACAS. So ACAS have been involved in the settlement discussions, and it can be completed by way of what's known as a COT3 agreement. The reason why employees can only waive their rights in limited circumstances is to avoid the situation where an employer takes advantage of an employee and gets them to waive their rights without having fair and reasonable compensation or understanding what they're agreeing to. It's thought that the employer is in a stronger bargaining position than the employee, which is why the employee is required to obtain legal advice on the content of a settlement agreement, which the employee normally contributes to the cost of. As I've said there, it normally includes the agreement to terminate employment, but it doesn't always. So in some circumstances where there may be a potential claim or a dispute that's arisen in relation to something like discrimination or harassment or bullying, an employee may just be offered a settlement agreement to agree to drop any potential claim, but their employment could continue. So their employment doesn't have to end. So what are the benefits of using a settlement agreement in your business? Well, the main thing is it obviously removes the risk. Once an employee has agreed to sign and had advice, then they are waiving the majority of their claims and can't pursue anything further. It does resolve things quickly, much more quickly than if there were a lengthy dispute, and with minimal stress for all involved. It protects confidentiality. So if you have an employee who has access to confidential information during the course of their employment, then you can reiterate within the agreement their confidentiality obligations. It also can deal with confidentiality of the dispute and the agreement so that it remains confidential. You can also retain post-termination protections, which is quite important for some businesses. Within employment contracts, you can have a post-termination restriction, which prevents an employee from soliciting or dealing with customers or trying to steal employees from you. You can reiterate those within the terms of a settlement agreement, or in some circumstances you can negotiate new post-termination protections for your business. So if you don't already have those in place but you want them, it's an opportunity to include them. You would have to pay the employee a sum of money in return for agreeing those, and it's normally part of the negotiations, but it is something that can be done. So it does offer that additional protection and confidentiality and restrictions for your business. Now, the reason why they're used in a redundancy situation is that it often avoids the uncertainty and stress amongst other staff. Now, quite often when I discuss issues of redundancy with employers and we talk about putting employees into a pool for redundancy, they're reluctant to do so because quite often they'll have 2 or 3 people who are doing the same job, and out of that 2 or 3, 2 are very good at their job and they really want to retain and they don't want them leaving and going elsewhere, and they might have one person who they think actually that would be the person, you know, I'm quite sure even if we did a fair selection criteria that would be the person to go. And they're worried that if they put all 3 into a pool for redundancy, that it may be the 2 good ones that go, or they might ask for voluntary redundancy, or they might just start looking for another job because they're concerned. So where employers want to ensure that the right person comes out of it as the person who's made redundant, then they will try to use a settlement agreement. And it can be a good way, as I say, of avoiding stress amongst the team and to resolve matters. I also find from advising employees on settlement agreements that ending their employment by way of a settlement agreement gives them some ownership to the process, and they feel that actually they have been in control as ultimately they're the ones that have decided to accept it and sign it. It's not always the case, but I think psychologically it does provide a little bit of assurance, and it's much easier for employees to move on from if they feel aggrieved rather than if they feel aggrieved and are made redundant or they're dismissed for some reason. And it also allows the future changes in the business to take place quickly. So if you're concerned that if you make redundancies you wouldn't be able to then make changes to the business because of a risk of a claim for unfair dismissal, if you use a settlement agreement, once the employee has signed it and waived their rights, then you're free to make those changes and to move forward as you need to with the business. So what are the risks if an employee declines a settlement agreement? So if you make that offer, essentially what you're doing is you're laying all your cards on the table, you're telling the employee what you're thinking of doing and how things may come out in the end. And there may be a concern that if the employee doesn't accept it, that they can then throw that back at you. Well, the general legal position is that if you're genuinely trying to settle a dispute, it can take place off the record and without prejudice, so that a party can't refer to it later on. But there has to be a genuine dispute in order to rely on the general without prejudice rule, as we call it. And there's been several cases on this as to whether there was a genuine dispute or not. And I would say in the situation where you're just making somebody redundant and avoiding the need to go through a consultation, it may be difficult to argue that. Now, helpfully, I think again about 2013, protected conversations were introduced, which means that employers now have the means, if you like, with confidence to have a conversation with an employee that cannot be referred to in any subsequent unfair dismissal claim. So this would be where you would rely on protected conversations to make that discussion about redundancy situations and settlement agreements. It does only apply to unfair dismissal claims, not any other claim. So if, let's just say, an employee declines a settlement agreement, and then you subsequently terminate their employment for whatever reason, and then they allege that it was discrimination, they may be able to refer back to that conversation in evidence. But you'd have to look at whether you can rely on the without prejudice principle. So if you are going to make a settlement agreement and you think there is a possibility that the employee will not accept your offer, it's important to get advice. I mean, it's important to get advice anyway before you start these conversations, because you want to make sure that you're framing them correctly and that you have everything in order. Now, I think if you, as I say, if you frame the discussions appropriately and you pitch the offer level at the right level for what the situation is, then 9 times out of 10 employees will take the offer. There may be some negotiation, but ultimately it ends in a settlement. I would say probably about 1 in 10 reject it altogether and return to work. But even in those situations, I would say again, the majority end up having some form of settlement at some point in the future. I have had a couple of situations where an employer has offered a settlement agreement, the employee has declined, and then the employee has remained in employment for some time afterwards. So things have kind of simmered down and the issue has been resolved. But it is very rare. Most of the time employees will accept them. So what do you need to do if you want to offer a settlement agreement? Well, the first thing you need to do is decide on what you want to offer them. How are you going to compensate them for what you're asking them to do? And you need to consider pitching it at the right level. This is where getting advice is really important, because you want to have a real consideration as to what could happen if they don't accept it and what the likely cost to you could be. Certainly, going down the settlement agreement route is more costly, with a sort of upfront cost, if you like, than going down the route of a redundancy consultation. But ultimately, the time taken, the additional wages, the management time, and the risks of going down the redundancy may outweigh offering them slightly more in terms of a settlement agreement payment. You need to decide very carefully on what you're going to say about the offer to the employee. How are you going to pitch it to them? What are you going to say about it? What are you going to say is the reason for it, and why you're making them the offer versus anybody else? And what are you going to say will happen if they don't accept the offer? So this is where having advice can really help. I always recommend that however you pitch it, you say, of course, no decision has been made, and that will depend on what happens after you've considered the offer. And so always caveating that this decision is not final. This is one route that you're considering for them, to give them the opportunity to agree a mutual settlement. You need to consider the timescale and cover for the employee whilst they're deciding on the offer. The ACAS guidance suggests that they should have 10 days, and I would certainly recommend, where possible, you enable them to have 10 days to consider the offer, seek advice and come back to you. I think it's realistic, a realistic timescale. Anything less than that, they may find it difficult to get advice. They may find it difficult to take everything in and consider in time, and you run the risk that a short timescale may put them under pressure to decline. Obviously, what you want to do wherever possible is to send the employee home and put them on paid leave while they're deciding what to do in relation to the agreement. You don't really want them continuing to work whilst they're contemplating the offer. So you may have to consider about having cover for them. You then need to prepare a letter to go with the settlement offer, setting out the details, and I always recommend you include a paragraph in there about the protected conversations and how it is without prejudice, just so that the employee understands under what regime you're having that discussion. And also, where possible, I recommend you give them the full settlement terms with the letter. The only time really where you may not want to give the full settlement terms is if you're not sure that they would accept the offer, or if you really think that they might reject it and you don't want to spend the additional costs in getting the settlement agreement drawn up in the event that they reject it. But as I say, most of the time I recommend it's the letter and the full terms so they can take those away and seek advice. So in the meeting with them, you inform them about the offer, you give them the paperwork, you try wherever possible to keep that meeting as short and sweet without going into details. Some employees will be stunned by this because you don't need to give them any warning of the meeting, you don't need to tell them what it's about in advance, you just need to have that chat, and they may be, very quiet and want to take it in and take it away. And then you get others who have a barrage of questions that they want to ask you, or they'll want to get into it with you about the situation and what you've said. My advice in those circumstances is to say the purpose of the meeting and the offer is to avoid having to go down that route of going into the details. If they don't want to accept the offer or they decide not to accept it, then you will have the opportunity to go through that with them in the future. So try not to get into too much conversation about the reasons behind it at that meeting. And then also it's important to think about your steps. If the employee rejects the offer, what are you going to do if they decide that they want to come back to work? How will that work logistically, and how are you going to manage things afterwards? Again, as I say, most employees will accept the offer after maybe some negotiations, but there are some who will insist on coming back. So that's just a rundown there on settlement agreements and why you might like to use them, particularly thinking about redundancy situations, but they can also be used in other disputes. If you're unsure, I do recommend that you get advice because you want to make sure you're covered by the rules about protected conversations or the without prejudice rule. Otherwise, the employee may just be able to use that as evidence against you, which could be quite costly in the future. As always, we have a number of resources for you. We work really hard to produce as much free information and content for employers and employees. We have, as I've listed there, we do have a fortnightly newsletter which is sent out by email, which the feedback on it is fantastic. People who receive it say they really like the content. We do make it as easy as possible for you to absorb and obtain without going into too much legalese. So if you're not already on the newsletter list and you'd like to be, then just let us know. You can email alison@realemploymentlawsadvice.co.uk and we'll put you on the mailing list. You can also go straight to our website, which is realemploymentlawsadvice.co.uk, where all of the resources that we produce are set out. So that's all of our articles, videos and podcasts. And we have recently had our website updated, so we have a fantastic search facility now. So if you type in what you're looking for, you will inevitably find a number of resources that can help you. So if you were looking for information about redundancy, then you type in redundancy and you'll find all the articles, podcasts and documents that we've produced in relation to that. So do have a look. We have a number of articles on LinkedIn. We've got the fortnightly podcast, which you can listen to on iTunes, Spotify, Google Podcasts. We have the YouTube channel where you may very well be watching this. We also have webinars, and we are on all the social media platforms where you can find updates and information. Do feel free to connect with any of us on LinkedIn. We do have, as I say, their articles, and I'm regularly posting updates as they come out and are available on there. So thanks very much for watching and listening to this presentation. Hopefully you found it useful. If you do have any questions or you'd like any advice or assistance, then myself and the team are here to help you. You can contact us by the telephone numbers that are on the bottom there, on our website, or by emailing any one of us. And my email is alison@realemploymentoradvice.co.uk. Thanks very much.